Masechet Baba Batra, Daf Kof Lamed Vav. We spoke a lot about someone making a statement on his deathbed. And this is a special law that the rabbis made, that if someone is on his deathbed, then even statements that he makes, even without making a transaction, are effective. So that if he says, I want to give this land as a gift to so-and-so, or I want to give this much land to this son, then it will take effect after he dies. So there's a special thing that he can say something while he's alive, and it will take effect after he dies. But now this next Mishnah is talking about someone who is healthy. And for a healthy person, they cannot use that mechanism. And so what if a healthy person wants to give something away, but for it to take effect after he dies? Of course, while he's alive and healthy, he can give a gift now, but then he has to give it up now, and he doesn't have it anymore. And if he says, okay, this is a gift after I die, that doesn't work, because after he's dead, he can't give a gift anymore. So what can he do in order to ensure that when he dies, the gift will go through, but he wants to say so from this point on? So that's what this Mishnah decides, tells us. Hakotev nechasav lebanav. Tzarich shichtov mehayom ulachar mita divrei Rabbi Yehuda. If someone wants to grant property to his sons, and this is out of the context of the usual inheritance, if it does nothing, then they will inherit anyway. But he wants to give this particular son something more, or he wants to give a gift to a different person. So whatever it is that he wants to arrange, or he wants to give certain sons from one marriage, that they should get everything and not from a different marriage. Okay, whatever the case is that he wants to do so, he has to write in the document, in the gift document or the will, from now and after death. So what does this mean? It's a complex phrase. Which one is it? Is it from now or is it after death? It means that I want the gift to happen from now, while I'm alive. That's when I can give it. So the land itself will be given and it belongs to my sons from now. However, I want it to fully take effect with regard to the produce only after death. So that way, the father can continue using that land, that field, and enjoy its profits while he's alive. And then the right to then use the profits afterwards, the right to own the land, will be transferred to the son automatically. Even it happens from now. And then once the father dies, then the son will have the total right. So it's a kind of two-step process. That's what Rabbi Yehuda says. You have to write that. Rabbi Yosef Omed eno sarich. Rabbi Yosef says you don't even have to write this mehayom ulachar mita. It's obvious if you just say that I'm giving this as a gift lachar mita. Then this is what it means. It means that it's being given from now, and the father can still use the produce from now, and then it will take effect after he dies. And you don't have to write this whole formula. We'll see why Rabbi Yosef says that you don't have to write the word mehayom, and still it can take effect from now, even though you said lachar mita. The Gemara will explain Rabbi Yosef's opinion. הכותב נכסיו לבנו לאחר מותו, האב אינו יכול למכור, מפני שהן כתובין לבן, והבן אינו יכול למכור מפני שהן ברשות האב. If someone does write that his property should go to his son after he dies, and this would be according to either opinion, either according to the Yehuda, where he wrote the word Mahayom, or according to the Yosef, where he didn't write the word Mahayom, but it's understood anyway. So what happens if one does that, and then one of the parties tries to sell the land? So, if a father writes that his son is going to get this after he dies, the father can no longer sell the land because the right to the land, the ownership of the land, already belongs to the son. So the father cannot sell it, all right, because they're written over to the son. And the son also cannot sell it because it's in the possession of the father. Even though the son has ownership rights, you could say current ownership rights or future ownership rights or the right to get it. There's different ways to think about it. But no matter what, the father is still in physical possession of it. He's the one living there or taking the fruit. So the son cannot sell it either. So what if they do sell it? It's only a partial sale. If the father sells it, that means he's selling the right to take the produce until the father dies. Since the father has the right to take produce, so he can sell to a different third party the right to take the produce, but then after the father dies, then the father himself no longer has that right, so the person he sold it to no longer has it either. And if the son sells the land while the father is alive, the buyer does not get anything until the father dies. Just like the son himself only has a future right to use the land, so if the son sells the land while the father is alive, then he's basically just selling the right in the future to take the land, so that he can sell now, but the buyer won't be able to use it at all until after the father dies. All right, good. Now Gemara explains. Even according to Rabbi Yehuda, how does writing this phrase even help? So what if you wrote today and after death? You think that's a clear language that it means, from today you get the right to the land, and after death, then you get the produce also. We see in a different context that a complex phrase like this is basically meaningless. We don't know what it means at all. Ha'tenan, mehayom ulachar mita, get ve'eno get, ve'emet holeset ve'lo mitya be'emet. We have a Mishnah Masechet Gitin that says, if a husband gives a get to his wife, and he says, I want this to take effect from today and after death. What does that mean? Does he mean today or after death? If he means, I want the get to go into effect today, but he's adding lachar mita as a condition, right? On condition that I die. So that if I die, then retroactively it's effective today. Well, then that is a good get. Once he dies, then retroactively it's a get, as long as he means it will take effect today. But it's not clear that that's what he means. Maybe what he means is, I'm giving it to you today, but I want it to take effect after I die. And we're married until the point that I die, and then after I die, then the get takes effect. That does not work, because a man cannot give a gift after he dies. He has to give a get while he's alive. So what he means to say is, I'm giving it to you today, but it should only take effect after I die. Well, then actually they are married the whole time. But if emphasis is on mehayom, that I want this to take effect today, right, with some conditional about dying, then it takes effect today, then it is a good get. So what do we do with this? Because it's a doubt. We don't know how to parse it. We don't know what this means. So it's a safek. It is a get and not a get. And that has a number of effects. That means while they're alive, she cannot go and get remarried. And if she gets remarried, then that's safek adultery. And the kids will be safek mamzerim. It gets very complicated then what will happen. So this is, we have to worry that it is a get and not a get. And if once the husband dies, let's say they have no children and there is a brother alive, then she has to do chalitza and not yibum. Because just in case it's not a get, that means that she is married to her first husband, and she has to do yibum. So she can't just go get remarried. She has to do something, yibum or chalitza. But she cannot do yibum because maybe the get was a valid get. And if she was not married to the husband when he died, then she's not allowed to be with the husband's brother. That's one of the adayot that lasts forever. Even if once she's married to a man, she's prohibited to all the brothers, even if they get divorced. And since they're divorced, yibum is not on the table. So she would have to do chalitza, because she's not sure if she has to do yibum or not. So we see here that in the same phrase, mehayom ulachar mita, it means one or the other, but it's actually a safek. So how come over here we say, this is a good language, we know exactly how to parse it, that it means that the land will go today and the produce will transfer after death. Why don't you say the same thing as we said in Masechet Gitin, that's just a safek, and we don't know what to do with this land. Hata mesapek alan I tena'a have, I chazara have, avalacha hachika amar le, gufa kene mehayom, pera lachar mita. And the answer is, regarding get, a get is an all or nothing situation. Either they are divorced or not divorced. Whereas regarding land, you can sell land in a two-step process. You can say, I'm giving you the land itself, and then I'm keeping the produce, and later on I'm giving you the produce. So because you can have a two-step process regarding land, that's why we assume that's what he means. From now, step one. After I die, step two. But a get is all or nothing. And therefore, we can't say it's a two-step process for a get. There's only the only ways to interpret his this statement is either he's making a condition, right? If I die, then retroactively you'll be divorced from today, in which case that's fine. Or maybe he means a retraction. He said from today, but then he says, no, I mean after death. So that means I'm giving you to today, but really I only want it to happen after death. Well, that means that it's not a get at all because he cannot give it after death. So because it's all or nothing, and we don't know if he means from today or if he means after death, then that's why it's a safek. But regarding the land inheritance, it's very possible that he means the land itself, you get it today. And the fruit, you get it after death, because you can make a two-step process. So we assume that is what he means. And so you see that the same phrase can be parsed differently in different legal contexts. And so that's a very important principle. Rabbi Yosef says you don't have to write the word behayom. The father can just say, this is yours, lachar mita. And even though he can't give a gift after death, we assume that he means from today. The Gemara will now explain Rabbi Yosef's reasoning through the following story. Rabba bar Avu chalash aligaber Rav Huna v'Rav Nachman. Rabba bar Avu was sick, and his students Rav Huna and Rav Nachman went to visit him. Amar le Rav Huna Rav Nachman be'amin halacha k'Rabbi Yosef o en halacha k'Rabbi Yosef. And so Rav Huna, who actually was older than Rav Nachman, nevertheless asked the younger Rav Nachman, go ask the Rabba bar Avu, is halacha like Rabbi Yosef or not like Rabbi Yosef? In other words, can you leave out mehayom like Rabbi Yosef says, or is halacha like Rabbi Yehuda that you have to write mehayom? Amar le ta'amed Rabbi Yosef layadana halacha ib'e mineh. And Rav Nachman says, I don't even understand the reasoning of Rabbi Yosef. I should ask what the halacha is. Usually first you ask what is his reason, what is his source. You want to understand it, and then after you discuss it and understand both sides, then you can ask, okay, what's the conclusion? You're telling me to jump right to the conclusion. What's the halacha? I don't even have an understanding of why he says that. And so Rav Huna says, if you ask what Rabba bar Avu, what the halacha is, I'll explain to you the reason afterwards. Right now we're sitting and we're visiting him, so just ask him this now. We have limited time. I'll explain to you the rest later. And so Rav Nachman did ask Rabba bar Avu, Amar le hachi amar Rav halacha k'Rabbi Yosef. And he answered, yes, indeed, halacha is like Rabbi Yosef. You don't have to write mehayom. Batadin faku amar le haynu tamed Rabbi Yosef damar zemano shel shtar mochiach alav tanya mehachi Rabbi Yosef omed eno sarich mipnei shezemano shel shtar mochiach alav. So after they finished their visit and they left, then Rav Huna explained to Rav Nachman, this is the reasoning for Rabbi Yosef, because he says that the date on the document proves when it took effect. So when you write a document, you put a date on it. So if it says in the document, the father writes, I am granting this piece of land to my son after death. Okay, he's right, it's true, he wrote after death, but he also wrote a date. So that means, when does he want it to take effect? Now. Well, how can it be that it takes effect now and be after death? Oh, it's the same as if you write mehayom ulachar mita. It means that the gift of the land is given from now, the right to take it eventually, but in the meantime, the father can use the produce. So instead of writing mehayom, you don't have to write mehayom because there's a date on the document. And there's a Braita that supports this explanation because it says explicitly, according to the Yosef, you don't have to write mehayom because the date in the document proves that it takes effect from that point and on. Be'amine Rava Rav Nachman bakna'a mahu amar le bakna'a eno sarich. Rava asked Rav Nachman, what if in the document it says that this transfer happened with a form of acquisition, behakna'a, right? We did it, the witnesses say, we saw an act of acquisition. So even though you don't write the word mehayom, but it says we made an acquisition. Well, if they said they made an acquisition, then doesn't that assume that they actually did some kind of action, maybe a kinyan chalipin, in order to transfer the land? And so that means it happened from that date. So is that sufficient, even without the word mehayom, if it mentions an acquisition? And Rav Nachman answers, you're right, yes, that's true. As long as it mentioned an acquisition, you don't have to write the word mehayom. V'Rav Papi amar ika aknayata de sarich v'ika aknayata de la sarich. Akneye ve'kanena mine la sarich. Kanena mine ve'akneye sarich. Rav Papa says actually it depends on the exact language. There are some languages of acquisition where you would still have to write mehayom, and some formulations where you wouldn't have to write mehayom. Which ones are they? If he writes akneye, the witnesses are signing to this and saying he, the father, transferred it. V'kanina mineh, and we acquired it from him. The witnesses are involved in the process as witnesses to it, or maybe they did the kinyan chalipin with the father. So if they say it in that order, right, that he transferred it and we transferred it, that is valid. Because then that's the normal formulation. And that means he said, I want to transfer that, and then we did it with him. So then for sure, we can assume they did an actual transfer, and that happens from that date. Therefore, you don't have to write mehayom. However, if they switch it around and they say, we acquired it from him and he transferred it, that's an unusual formula. So it means there's something off about that. All right, it doesn't quite make sense to say, we acquired it and he acquired and he transferred it, because he has to do something first. He has to say, I want to do it, and then say, okay, we followed up. So because it's the wrong way around, the unusual formula, it means that maybe they didn't actually do a transfer, an active acquisition, and therefore you have to write mehayom to confirm that in fact the father meant to transfer it on that very day. Matkif la Rav Hanina misura mi kamidi da'ana nayad inan v'safre yad'eh. So Rav Hanina from Surah rejects the statement of Rav Papi. He says this is very subtle. Rav Hanina is like, we didn't know this ourselves, these students, until you taught it to us. So can there be something that we ourselves, the sages, don't know, but the scribes know? Generally, the scribes were not that learned. I mean, they knew certain things. They knew their trade, their craft. They knew how to get ink and writing material, and they knew how to write well, and they knew the formulations of the forms of a get and a ketubah, and other business documents. So they had certain specialty knowledge, but they weren't the greatest chachamim in terms of the halacha. So the Papi, you're teaching us this new and interesting law that's very subtle that we just learned. So, but for this to work, that would assume that the scribes already know the difference and will write it this way if there was an acquisition, and write it just a subtly different way if there's no acquisition. Do they really know all that, and we don't even know it? So they went and tested them. So they went and asked the scribes that worked with Abaye and the scribes that worked with Rava, and in fact they did know this distinction. So you see that even though the scribes may not know everything by heart and not the greatest Talmid Chachamim, but they do know a lot about writing such forms, and so they were well aware of this distinction, and therefore it makes sense that this distinction would be true. It happens a lot. Sometimes a great expert doesn't know some of the details. Sometimes you go to a hospital and the nurses know more about certain things than the doctors, because the nurses are dealing with these nitty-gritty things every day that the doctors are not. Okay, Rav Huna bered Rav Yoshua Amar, Ben akneye ve'kanena mineh, Ben kanena mineh ve'akneye la sarich. Rav Huna, the son of Rav Yoshua, disagrees with what Rav Nachman said before. This was all asked by Rava and answered by Rav Nachman, and then clarified by Rav Papi. So Rav Nachman is the one that said, as long as acquisition, that's okay. And Rav Papi says it depends on which way it is, and there was a rejection, but then a confirmation of that. So that was all that opinion. But now Rav Huna, son of Rav Yoshua, says against Rav Papi, is actually in agreement with Rav Nachman. Rav Nachman said a general statement, as long as there is acquisition, that's all you need. Rav Papi says, well, it depends on how you write the acquisition, and Rav Huna says no, it doesn't make a difference as long as it says we made an acquisition somewhere in there. That means they made a formal transfer on that day, and so there you don't have to write mehayom. So that Rav Huna is disagreeing with Rav Papi here, and but both of these, Rav Papi and Rav Huna, Bered Rav Yoshua, are statements within the Rav Nachman. Rav Nachman said a more general statement that that as long as there is hakna'ah, right, then you don't have to write it. Then the question is, do you have to write it a certain way or any way that you write it? I'm saying all this because we're going to see another version in a second. And Rav Huna, son of Rav Yoshua, added another law, ube duchran pitgamed ava be'an pana pelige. If it doesn't say anything about an acquisition, rather the document just says, here's a record, a duchran, a memory, a record of the proceedings that took place in our presence. It just says that, and it doesn't mention anything about a transfer. That's what the case of the Mishnah is talking about, where there is a machloket. And Rabbi Yehuda says, it doesn't say an acquisition, well then you need the words mehayom. And Rabbi Yosef says, even though it doesn't say an acquisition, and they still don't need the word mehayom, because you have the date, and the date is sufficient. Good. Amar Rav Kahana, Amrita halishmata kamed Rav Zevid min Nehar De'ah. Rav Kahana says, I repeated all that in front of Rav Zevid from Nehar De'ah. Ve'amar li, atun hachimat nitula, anan hachimat ninan la. I understand that's how you taught this sugya. We taught this back and forth slightly differently, in a simpler way. Amar Rav Nachman, be'akna eno sarich, ben akniye ve'kanen amine, ben kanen amine ve'akniye la sarich, beduchran, pitkamed, avu be'anpara, Anpana pelige. According to our version, it's not that Rava first asked Rav Nachman and Rava answered, but rather Rav Nachman stated all this, and Rava is reporting everything Rav Nachman said, and it was not a question and answer, but rather it's just a statement. As long as there is an acquisition, you don't have to write the word mehayom. And furthermore, it makes no difference whether you use this formulation or that formulation. So this is not only the opinion over here of Rav Huna, it just says it was skipping. It skips Rav Papi, it skips the question and answer here. And it doesn't say that this is the opinion of Rav Huna. It just says all this in the name of Rav Nachman. And it ends off with saying the last statement that if you don't write anything about an acquisition at all, well, that's the machloket between Rabbi Yehuda that says if you don't have an acquisition, then you have to write mehayom. And Rabbi Yosef said you can have neither of them and the date is sufficient. It would seem that the earlier version is probably this first one here that has a question and an answer and a discussion by several different sages until we got to the conclusion, whereas this version looks like a summary of everything above. And the summary is quoting everything, just quoting the beginning, what Rav Nachman said, and all the conclusions of the clarifications that were by different sages. It just takes out all their names and says, here, this is the meaning of what Rav Nachman said. So this is actually a very nice example of the two different ways that a transmission can happen. A transmission of a teaching might include all the different stages of questions and answers and commentaries. And another form of it is, okay, who needs all the questions and answers? What's the bottom line? What did he say? And what does it mean? Put it all together. And that's the second version here. HaKotev nechasav libno la'achar moto. So the Mishnah said if someone writes a document that says I'm going to give to my son the property after he dies, so then that works and the son has it after the father dies, but in the meantime the father gets the produce, and the Mishnah discussed what happens if one of them tries to sell it, and so on. Now we have a follow-up on that. Itamar, machar haben bechaye ha'av, umet haben bechaye ha'av. So we have a case where the father wrote such a document, mehayom lachad mita, and then that means the father has the produce and the son has a right to receive the land eventually. Now, if the son sells the land while the father is alive, the Mishnah already addressed that case. It means the recipient doesn't get anything until the father dies. At that point, then it makes sense. Then the son would have it, and the son already sold it to someone else, so then the recipient gets it. But here's the complication. What if the son dies while the father is alive? So the father wrote this document and gave the son the land. The son wrote a document selling the land to his friend, but then that son dies. So here's the question. When the father dies, does it go to that buyer or not? Machloket. Amar Rabbi Yochanan. Lo kana lokeach. V'Reish Lakish amar kana lokeach. Rabbi Yochanan amar lo kana lokeach kinyan perot ki kinyan haguf tameh. Rabbi Yochanan says there is no transfer. Reish Lakish says there is a transfer. And the Gemara explains, according to Rabbi Yochanan, that buyer does not receive it. Why? Because selling produce, rather acquiring produce, is like acquiring the item itself. According to the Yochanan, what's the main part of the right of ownership? It's the right to use the item. And so because the father is the one that has a right to use the produce, so the father actually has the ownership rights of the land itself. So what did he sell to the son? He only sold to the son the future right to get the land once the father dies. And that's something that's intangible. Although it works and he can transfer that from now while he's alive, so that eventually when he dies, then the son gets the whole thing. But it's too intangible for the son to be able to sell to someone else. He doesn't have enough of a possession to be able to sell it. And therefore, since the son sold it while the son was alive, and then the son died, he sold something that didn't yet exist. He didn't actually own the land yet to sell it. So when the father dies, then it does not go to that buyer, it will go to the normal legal heirs. Whereas Resh Lakish amar kana lokeach kinyan perot lav kekinyan haguf tameh. Resh Lakish says in general, the possession of the fruits, of the right to collect the fruits, is not like ownership of the land itself. Rather, it's a separate thing. You can rent out an item to use, but you're not the owner. And therefore, the father, who only has the right to the produce, is not the first primary owner, but rather the son himself. Even when the father is alive, when he says, I'm giving you this land from now and after death, that means the son gets the land from now, and the produce will get after death. That means the son has something tangible. He actually is the owner of the land. So when the son, while he's alive, sells it to his friend, it's a real sale. And even if the son dies, nevertheless, that sale goes through, and eventually when the father dies, that buyer gets the entire land. Okay, now we have machloket and the explanation of the machloket. The next question is, why do we need for this statement to teach us this machloket, since we already know that Rabbi Yochanan and Resh Lakish disagree about this very principle in a different context? They already discussed this in a different time. Why do I need to be taught it again? Let's say someone owns land in Israel and he sells to someone else the right to take the produce, right, for a certain amount of time. And so now that farmer that has the right, he is collecting the harvest of all the fruits. Does he have to bring bikurim? Yes, he has to bring bikurim because the Torah says, right, if you're harvesting the fruits, you have to bring bikurim. The question is, can he say the recitation of mikra bikurim? The recitation says, thank you Hashem for the land that you have given me. Now, but he doesn't really own the land. So Rabbi Yochanan says, that farmer, the renter, can bring the fruit, and he can say also the statement, he can recite it. Why? Because according to Rabbi Yochanan, ownership of the fruit is like ownership of the land itself. And for that time period, whenever, as long as he can take the produce, he can say, I'm the owner of the land. So he can say it. Whereas according to Resh Lakish, he brings the fruit, but he cannot say the statement because ownership of the produce is not like ownership of the land. And therefore, he can't say a lie. He can't say, thank you for the land that you have given me. He only owns the fruit, not the land. As the Gemara now explains, Rabbi Yochanan amar mevi vekoreh kasavar kinyan perot kinyan haguf tameh, Resh Lakish amar mevi ve'eno koreh kinyan perot lav kinyan haguf tameh. Rabbi Yochanan says he can bring and recite because he thinks that ownership of the produce is like ownership of the land, and Resh Lakish says he brings but does not recite because ownership of the produce is not like ownership of the land itself. So why do I need to say the machloket regarding the father and son if I already know it regarding the fruit? Amar lach Rabbi Yochanan, afal gav de be'alma kinyan perot ki kinyan haguf tameh, hacha isterich salkada tech amina, abba legabe bere achule achil kamash malan. Rabbi Yochanan says, even though in general I know that according to Rabbi Yochanan, ownership of the produce is like ownership of the item itself, and we now know that from Mikra Bikurim. I nevertheless need for Rabbi Yochanan to teach it here as well, because I might have thought that it applies differently in the case of a father and son. I might have thought that when a father is giving something to his son, a father wants to be very generous, and he waives any rights to the ownership of the actual land. And the father, by being generous, he's saying, listen, I just want to have some fruit, but the actual ownership of the land, you son, I want you to have the whole thing. And therefore, if the son sells it and then dies, the sale would be a good sale. I might have thought that. Rabbi Yochanan would say that. And that's why I need this statement to teach me that even according to Rabbi Yochanan, a father, if he retains the right to the produce, is retaining the right to the actual land itself. All he's selling to the son is a right that in the future he can get it, but that's not something tangible that can be transferred. Rabbi Shimon ben Lakish amar, Af agav de be'alma kinyan perot lav ki kinyan haguf tameh, hacha isterich. Sakadatecha mina kol legabe nafshe, afilu b'mkom bereh, nafshe adif aleh, ka mashma lan. Rabbi Resh Lakish says, even though I know in general that the ownership of the produce is not like ownership of the land, and that's what he said regarding mikra bikurim. However, nevertheless, I need for Resh to say the statement of Resh Lakish here as well regarding the father and son, because I might have thought that any time it comes to one's personal self, then even as opposed to his son, that person always is going to prefer himself. In other words, I might have interpreted Resh Lakish as follows: a person always is going to keep the primary ownership of the land for himself. So in the case of the Mikra Bikurim, where it so happens that the owner is only giving the right to the produce, that then he's keeping the right of the ownership of the land because he always wants to keep the ownership of the land. And if the situation was reversed, as it is in our case, where the father is giving away the right to take the land in the future, but keeping the produce, maybe there also he would say, I'm keeping for myself the primary ownership of the land. So in other words, I might have thought, according to Resh Lakish, that it's not about who owns the produce and who owns the land, but rather the produce can go either way. The point is that whoever is giving something away is going to give as little as possible away. And therefore, in the case of Mikra Bikurim, I'm giving you only the produce. But that's it, not the main ownership. And here also, I might have thought that the father is giving to the son the future right to possess, but not the current primary ownership. I might have thought in either case, the father is keeping it for himself. And that's why I have to say, not so. Rather, it's always the opposite of the produce. Having the produce is a very nice thing, but the ownership of the land is the opposite of the produce, and therefore I wouldn't necessarily know that unless Resh Lakish taught me that in this case, a father who keeps the produce but gives away the land, no, the land goes totally. And a person doesn't necessarily always keep the primary thing for himself. If he's only keeping the produce and not the land, then he is in fact giving away the land, and that is something that the son can give away even during his lifetime, so that even if the son dies before the father, and then eventually the father dies, the land will go to that buyer. Itibe Rabbi Yochanan leResh Lakish Nechasai lecha v'acharecha yirash peloni v'acharav yirash peloni met rishon kana sheni met sheni kana shelishi met sheni bechayei rishon yachzru nechasim liyorshe rishon v'im ita liyorshe noten mi ba'ele. Rabbi Yochanan challenges Resh Lakish from the following baraita. If someone says, I want, this is someone who owns property, and he says, I want this property to go to you, Mr. A. And after you die, I don't want it to go to your heirs, Mr. A, but rather I want it to go to Mr. B. And after Mr. B dies, it shouldn't go to the natural heirs of Mr. B, but rather I want Mr. C to get it. So if they die in order, so when this guy dies who owns it, and it goes to Mr. A. When Mr. A dies, Mr. B gets it. When Mr. B dies, Mr. C gets it. So that works. So that is a valid formulation. However, Metsheni bechayei rishon, let's say this guy, he said the same formulation, and he died and it went to Mr. A. But while Mr. A is alive, Mr. B dies. Is it going to skip to Mr. C? It can't. There's no way for it to get there. It has to go through the chain of custody, the chain that the deceased said that he wants it to go in this way. But if it never went to Mr. B, then there's no way for Mr. B to give it over to Mr. C. And therefore, if Mr. B dies, and then Mr. A, eventually Mr. A dies, it will go to the heirs of Mr. A and will not go to C. That's the end of the Braita. And now, here is the question, Vim ita, if it's true, as you say, Resh Lakish, that ownership of the produce is not like ownership of the land, well, in that case, what is the father actually giving over to Mr. A, B, and C? He's only giving the produce, not the land, because basically saying, Mr. A, I want you to enjoy the produce while you're alive. And after that, if he said, I'm giving you the whole land, then it would go to the heirs of A. That's it, he's giving everything to A. But instead he's saying, listen, I want you to use it while you're alive. And then I want B to use it, and then C to use it. He's only giving over the produce to A, B, and C. But what about the land? If, according to Resh Lakish, you say that he's not giving over the land because ownership of the produce is not like ownership of the land, so who actually owns the land this whole time? It's actually the deceased, the one who he owned the land, and when he dies, it's really his heirs. Let's say he has a son who is the owner of the land. Now, in the meantime, A gets to use the land his whole life, and then B his whole life, and then C his whole life. But really, A owns the land, and eventually it could go back, maybe after a generation or two, it will go back to the heirs of the original deceased guy. Therefore, in this case, where B dies before A, once A dies, so then that's it. It's not going to go to C because it lost the chain of transmission there. So who should get it? It shouldn't stay with the heirs of A, as the Braita says. According to you, Resh Lakish, A only owned the produce, and produce is not like the land itself, so it should go to the heirs of the original owner who died. And yet that's not what it says. So there's a challenge to Resh Lakish. See, this makes sense according to Rabbi Yochanan, because according to Rabbi Yochanan, ownership of produce is like ownership of the actual item. And therefore, this father who has it and gives it to A, B, and C, he is giving over not just the produce, but the produce is, in effect, the primary ownership of the land as well. And therefore, he's giving over the ownership of the land to A. And that's why if A has it and B dies while A is alive, then it stays with the heirs of A. But according to you, Resh Lakish, the ownership of the land remained with the original owner the whole time. So that's a good question. And Resh Lakish has an answer. Amar le kevatir gemar Rav Hoshaya beBavel acharecha shaneh vechen remeh Rabba bar Rav Huna kamed Rav ve'amar acharecha shaneh. Resh Lakish says, really, I stick with my point that ownership of produce is not like ownership of the land. And your question is a good question. How come in this case it will remain with A if B dies while A is alive? Oh, Rav Hoshaya already explained that if you add the word acharecha, this is a different story altogether than a regular statement of, this is yours, but I'm from now lachar mita. When you say acharecha, that means I'm granting you full ownership A for now, during your lifetime. But it's a full ownership, produce and the land itself. And by saying acharecha, he's saying you get it during your lifetime. And after you, then I say from now, I want the whole thing to be transferred over to Mr. B. The entire ownership, produce and land, and afterwards to Mr. C. And that's why, see, acharecha is different from a regular statement. And this explanation Rav Hoshaya gave in Bavel, also Rabba bar Rav Huna stated before Rav, and he said, in fact, he asked this, Rabba bar Rav Huna asked this very question before Rav, and Rav answered, acharecha is different. So Shakish says, I am consistent. If you don't use the word acharecha, but rather, like in our case, the father who says, this is yours, mehayom ulachar mita, then the produce, the father keeps the produce, and the son gets the land, and ownership of the produce is not like ownership of the land, and therefore the son would have a right to sell it, and that sale would be valid, and that buyer would get it once the father dies. But if you say acharecha, that means I'm giving you the whole thing, because I said, and after you, then it goes to someone else. That assumes that I'm actually giving you primary ownership of the entire land. Baruch Adonai le'olam. Amen ve'amen.